Great. Good afternoon, everyone. I want to thank everyone taking time out of their busy schedules to be with us today, especially on this rainy, gloomy day. So I hope all of you are cuddling up or have something warm as we get through this webinar. So my name is Kristin Schreckenbach, Director of Wealth Solutions in our Sustainable Wealth Management Division. And welcome to Vancity's 2023 Financial Literacy Month series of webinars. I'll be kicking off today's session. I'd like to first begin by acknowledging that Vancity operates on the unceded lands of the Coast Salish people, represented today by the Musqueam, Squamish, and Tsleil-Waututh nations. They have been custodians of this land since time immemorial, and as visitors, we'd like to start this webinar by paying our deep respects to the elders of the past, present, and leaders up and coming. We'll be hosting a set of free webinars every Thursday in the month of November, featuring topics on estate planning, retirement planning, investments, and savings for your kids' education. Today's webinar is on estate planning, in particular, the topic of transferring wealth and assets. This webinar will be recorded and then shared with the registered attendees. It will also be posted on our YouTube channel following the event. If you haven't already, please make sure you follow us on YouTube and our various social media platforms to stay connected and get access to content like this webinar. The Q&A button allows you to submit a question. We will be answering questions after the presentation. I would also like to introduce Barry Osmond, Manager of Vancity Investment Management, who will be monitoring the Q&A and providing closing remarks for this webinar. Lastly, we encourage you to engage with us throughout the webinar and take note of what's most valuable and what might be most helpful to you. So with this, I'd like to introduce our speakers for this webinar. Tina Cheung, Wealth Advisor. Tina is born and raised in Vancouver and has been in the investment industry for 15 years, supporting members in different life stages to achieve their financial goals. As a wealth advisor, she works with members to create a roadmap that helps them achieve their financial goals and planning objectives using different investment and financial planning strategies. Tina holds the following designations: Certified Financial Planner, Certified Professional Consultant on Aging, and Responsible Investment Specialist. Our second speaker is Ricky Retel, Wealth Protection Specialist, having over 12 years of experience in the financial services industry. Ricky was an independent advisor with Desjardins Insurance and Retel Financial, and has worked at other known insurance firms. He takes pride in member satisfaction and is always willing to go that extra mile, all the while collaborating with advisors in the credit union space to ensure our members are well protected from life's curveballs. In his spare time, he devotes a lot of time and effort on the soccer field, developing youth soccer players in an academy program. He is also a very proud sponsor and advocate of the BC Lupus Society, which he holds near and dear to his heart. So with that, I'm going to pass it over to Tina. Thank you.
Thank you, Kristin. Hello and good afternoon, everyone. Thank you for joining in. We often get asked, what are some ways to transfer asset and how can I plan for that? But before discussing some of the ways to transfer assets, let's take a step back. Not often people will want to talk about death or talk about tax. But it's an important one because you work so hard to accumulate your assets and you most likely want to transfer it in the best way possible. So what happens when someone passes away? First, you need to retrieve identification and passports, and driver's license. Need to consider how to deal with digital assets like Facebook and Instagram. Does the deceased want to keep it open for others to have memory of them or close it? Deal with monthly subscriptions like Spotify and Netflix. If there is a pension or insurance company, you need to notify them. Essentially, all their financial and personal affairs need to be handled and their will is in effect. So what is a will? It's a legal document with instructions on what you want done with everything that you own at death. In the legal document, you will need to choose an executor. Things to consider when choosing an executor. On this particular slide, you see that you may want to think about their experience, their knowledge, whether they have time to carry out their responsibilities. Are they impartial? Are they trustworthy? As well as age and health. I will not elect my father as an executor, not because I don't trust him, but as he is in his 80s, as I get older, so does he. This slide captures all their responsibilities, and I'll just mention a few. Notifying beneficiaries, applying for probate, filing for your tax return. Needless to say, it's a big job as you're carrying out all these tasks and while managing grief. Because it's a big job, the executor can receive compensation. On the following slide, in the absence of when there is not a specific fee provision in the will or a separate executor compensation agreement, the maximum amount of executor compensation is set by the provincial government in the Trustee Act. The same rate applies as an individual as well as a corporate executors. A compensation agreement is signed while the will maker is still alive and may set any amount of compensation as agreed. If there is no compensation agreement made by the will maker, all the beneficiary or the court must approve the executor compensation amount. So what happens when a will is not in place? It's deemed to be intestacy. In this particular situation, you need to go to the court, you got to appoint an administrator, which takes time and often costly. And there's also distinct rules in each province and territory dictating how assets will be distributed. The purpose for probate fees is to cover the cost of administrating the estate, such as fees, court fees, administrative fees, and other expenses that is noted on this slide. On this slide, I'm going to give an illustration on how probate is calculated. Probate fees is charged on the fair market value of your estate asset. For illustration purposes, if your asset value is at a fair market value of $100,000, for assets under $25,000, there'd be no charge at all. Anything between that and $50,000, there is a 0.60 of the estate value. Roughly, it's about $150. Anything above that $50,000 is charged at 1.4% of the estate value. And there's always going to be a fee, an application fee, which is going to be $200. So for our illustration purposes of $100,000 fair market value estate, roughly there'd be a $1,050 probate fee. Well, there are things that does not hit the estate. There are assets that does not form part of your estate by simply naming a beneficiary. By doing so, the asset will transfer directly to them. For example, naming a beneficiary in your registered retirement savings plan, your tax-free savings account, setting up a trust, gifting while you're alive, or maybe even considering a loan, provide them a loan. So there are things that you may want to consider when naming a beneficiary inside your RRSP. It may not be the best idea to name the estate as a beneficiary, as it opens up to the possibility of creditors, family members contesting the will. Don't transfer assets directly to a minor child. Best practice is to name the estate as a beneficiary and create a testamentary trust for the minor. Things happen, life happens, and for example, someone may forget to remove their ex-spouse or name a new spouse as a beneficiary. So a few years ago, I was looking at my husband's annual pension statement from his company, and my name was nowhere to be found on that statement. And I definitely saw his brother's name on it. And I'm saying this on a smile right now, but at that moment, I wasn't smiling. I'm like, I thought we updated this. And he just goes, oh, I thought so too. The plot is not. So those are the things you might want to consider, because it's important to do so because it can lead to undesired distribution. Don't name and infirm dependent children or grandchildren without getting professional advice, as it may reduce their provincial disability assistance benefits. Let's talk about registered retirement savings plan. These plans are usually set up by the parent or the parents to save for their children's education. Most often we see the plans jointly held. For example, both parents' names are on the account. Then in the event of one's death, the plan will continue to be held by the surviving parent. If the plan is not jointly held, it's a good idea to instruct it in your will as to who will continue managing the registered retirement savings plan. And maybe it's best to continue to build the education savings plan using the funds in the estate. If there is no joint holder, nor is it addressed in your will, then the plan must be closed. Most likely will be closed. The asset will form part of the estate. It would be distributed to the beneficiary based on your will. And most importantly, the grant portion is repaid back to the government. Let's switch gears and talk about designating beneficiary under a tax-free savings account. In BC, you can name anyone as a beneficiary. Upon death of the holder, the beneficiary will receive the funds tax-free. If no designated beneficiary, proceeds are paid to the holder's estate. Another option is to elect a successor holder as a beneficiary, but it's only available for spouse and common law partner. And upon death of the account holder, the appointed spouse or common law partner becomes the owner of the tax-free savings account. For example, if both partners have $100,000 each in their respective tax-free savings account, and they name each other as successor holders, in the event of one's passing, the surviving spouse will have one TFSA, one tax-free savings account with a value of $200,000 to continue to grow tax-free, and that's a significant amount. To summarize, a successor holder will receive the tax-free savings account with the funds still held within it, whereas a beneficiary will receive the funds from the TFSA and the deceased TFSA account would be closed. Now, you may be thinking, which option is better for me? Is it electing a successor holder or a designated beneficiary? Common practice is if you have a spouse and common law partner, generally it's better to name them a successor holder. If the beneficiary is a minor, instead of naming them directly on the tax-free savings account, best practice is to name the estate as a beneficiary and create a testamentary trust for the minor in the will and have the funds in the TFSA proceeds to them that way. Here at Van City, we can do both. You can name a successor holder and a beneficiary. This way, if the successor holder predeceases the original account holder, the designated beneficiaries will receive the funds instead. Earlier on, you've heard me use the term testamentary trust. So let's take a moment to talk about this. Testamentary trust is effective after death. A few reasons why one would set up a testamentary trust after death is to manage an inheritance until the minor beneficiary is old enough and importantly responsible enough to take control, to manage the funds for a disabled beneficiary that's not capable of managing the funds themselves. 3, creating a discretionary trust where the trustee controls the distributions for the disabled beneficiary to generally prevent government disability benefit being clawed back. And lastly, to create income splitting between the trust and the estate beneficiary for tax purposes. On the other hand, an intro vivos trust is set up during your lifetime. What are the reasons to set up? For income splitting, business interest, like for example, you want to do a corporate estate freeze or a will alternative. The trust does not form part of the estate at death, nor is it subject to will's variation. There would definitely be costs that's involved, like legal costs, annual tax return filing, and depending who's managing the trust and what is it invested in, you can expect to incur trustee fees and asset management expenses. It is important to note that when you transfer assets to the trust, it can trigger immediate deemed disposition, capital gains, taxable capital gain. An example would be if someone transfer a rental property into the trust, it is deemed that they sold the asset at fair market value, which will create taxable capital gains even though you didn't sell it. On this slide, we get this question often. Is it best to outright gift the asset or provide a loan? Should I gift or should I provide a loan? I remind my members that they have the right to gift during their lifetime. Everyone does, as long as it's done freely, with full knowledge and consent, and without undue influence or coercion. Also, it's important to factor in the tax consequences when gifting. But something we also forget is factoring the feeling of another child in the family who may resent the gift, especially when the gift has a high value or a sentimental value, such as a collectible, a jewelry, or art. When gifting these items, it would be advisable to document the gift by the way of deed of gift, so your intentions is clear, and so there's no misunderstanding, and there are no issue with estate after death. Changing ownership may trigger immediate taxable gains, such as brokerage account and rental property. Kind of touched on that. But what we didn't touch on is that the potential for income being attributed back to you if the gift is to a spouse or a minor child. The federal government has put in place a number of rules to prevent income splitting in many situations, and they're known as attribution rules. You may have heard of it. And these rules prevent an individual from simply passing one portion of their income to reduce the overall taxes, family taxes. Essentially, the income your spouse earns on funds that you've gifted will continue to be attributed back to you. So you're paying for the taxes. So that is why there are situations where instead of changing ownership or gifting, perhaps consider providing a loan. And through the loan document, you're going to mention, is it advance in inheritance or to be forgiven upon your death? Joint accounts. but a juicy one. Not all joint accounts are equal. When a joint holder passes away, only joint with right or survivorships let the other joint owners potentially keep the deceased shares without probate. Whereas joint tenant in common, each party owns a percentage of the asset. It does not have to be equal. Shares of the asset does not pass to the other joint tenants upon death, but instead forms part of the deceased tenant's estate. Therefore, a joint tenant in common can gift their share of the asset in their will. But be mindful and careful when adding an adult child as a joint owner. Placing property such as principal resident, financial accounts in joint name is a common strategy to avoid probate fees. But let me tell you, sometimes it does not even avoid probate fees, and it actually will create other taxes and estate problems. And I would like to touch on a few. By adding your adult child to a property, you may lose the eligibility to claim your home as a principal resident. And this can be a significant amount of taxable capital gain, especially in the Lower Mainland in Metro Vancouver. Number two, it may trigger immediate taxable capital gains on your brokerage and your rental property. It may expose your assets to family law or creditor claims against the new joint owner. For example, if my father decided to add me to his brokerage account, in the event of my relationship breakdown, half of the account is exposed to family property right for division. And true story, my dad did ask me, he's like, he calls me daughter, like I want to add you to one of my accounts. And I told him exactly what I just told you. And surprisingly, he wasn't kind of concerned about that aspect, but he was more concerned, you're already thinking about getting divorced? So when holding an asset jointly with the child, there needs to be a clearly documented intentions. Otherwise, the assets may be seen by the court that is held in trust by the child or the parent and becomes part of the state distribution. That means you will pay probate regardless and potentially will variation claim. So it's best that you clearly indicate your intention by preparing a document with the help of a lawyer. So before I close, I would like to share a story with you because we most recently updated our will. Our little toddler is 2.5 years old, and we needed to name a legal guardian. I have to be honest, I've been doing this for a while, but it wasn't the most enjoyable topic to discuss with my partner because we're talking about what happens to him if we die. Also, discussing who would be the best legal guardian and that the dreaded conversation of having to inform why we picked one family member over the other. And it was a sensitive conversation, but we knew it was an important one and it was a critical one because we wanted somebody that we trust. And we wanted it somebody that we know that will put his interests first, will advise him, manage his assets, and oversee his care. So if this wasn't in place and just something bad happens to us, the public guardian trustee will get involved if we didn't name a legal guardian through our will. And besides the fact that the public guardian trustee will charge a fee, they will actually release all the funds at age 19. And kid you not, at this stage and his personality trajectory, I don't trust him a whole lot. But why I want to share this with you is because we wanted to be able to control when, how much, and at what age the funds can be released. But under the public guardian trustee, they are legally obligated to release the funds at 19, no matter how much it is, regardless of his maturity level and financial responsibility. So to conclude, the outcome of death may not match what the intentions were while alive. And that is why it's important to consider all your options on how to transfer wealth in efforts to safeguard your assets while having your intentions clearly executed. So thank you for your time. I now will pass it on the virtual floor to Ricky Retel.
Thank you, Tina. Awesome job. Good afternoon, everybody. My name is Ricky Retel. Thank you for joining us today. I'm the Wealth Protection Specialist here at Vancity and have been for the last 5 years. I thought it would be important to speak about what we do and some of the things that we implement so that we can mitigate some of the costs that come with dying prematurely. So what do we do and how do we do it? A lot of our job really is to protect our members should they die too soon, live too long, or become sick or disabled along the way. And so how do we do that? We have tools in our tool belt that will help our members in these types of events. So we do offer life insurance, whether that's term life or permanent. We also have living benefits. So this is a living benefits in case you are disabled and unable to work. There's a disability plan in place where you can collect a monthly indemnity until you're able to get back to work. Critical illness insurance, this is fairly new. I would say 25 to 30 years. It was actually invented by a doctor. What this does is in the event that you're diagnosed with a critical illness, you're paid out a tax-free lump sum to get yourself better, look for alternative treatments, pay for prescription drugs, or just pay your monthly expenses until you're able to get back to work. Business insurance is something we also offer. We have a lot of business members here at Vancity. And so key person life insurance becomes very important when there are multiple partners in a business, as well as group benefits. Sometimes they have many employees, and in order to retain those employees, they want to offer them a group benefit plan. This is something we do here at Vancity. Now, I've been asked the question quite a bit as to, well, why should I do business with you and why Vancity? Well, the nice thing here at Vancity is that we're contracted with multiple insurance companies, so we truly do have your best interests at heart. We don't have any proprietary products. This is something that, you know, I really like to advocate for because we can use Manulife or Empire Life or Canada Life. We don't just have to use one insurer when we're looking for the best plan for our members and hopefully at the best cost. Now, for estate planning purposes, I thought I would hone in on life insurance because I think it's very important. There are things that we don't really think about when it comes to costs when someone dies prematurely, and term life insurance or permanent insurance in this case can solve that problem. So when we look at term insurance and permanent, oftentimes we advisors like to mix our members' plans with both because sometimes they have an outstanding mortgage that they want to make sure that their surviving spouse can keep if they pass away prematurely. And so these are what we call temporary insurance needs. Student loans is another one, business loans, education costs for children. But I really want to focus in here on the permanent life insurance aspect because there are some things that never go away and some costs that never go away. One is taxes, and two is final expenses. And so when we look at final expenses, what are we actually talking about? Final expenses can include a funeral cost, such as a burial or cremation and celebration of life. I know, having been in the industry for the past 15 years, that a rough estimate as to a cremation is between $2,000 and $5,000, and if there's a burial, it would be between $5,000 and $10,000. And then the celebration of life could be thousands of dollars, depending on how many people are attending. Obviously, there are executor fees and things like that as well, which could run up a couple $1,000s as well. So sometimes when we're putting these plans in place for our members, we usually suggest and recommend anywhere between $10,000 and $25,000 for final expenses coverage. The last 2 points here for permanent life insurance, I think some people have not heard of or are unaware, but Tina made reference to, capital gains taxes at death. This becomes a real problem when there's multiple properties that one owns, or perhaps they own, some type of revenue property. I wanted to talk about an opportunity I worked with one of our wealth advisors, and it was a couple in their 50s, late 50s. They owned a strip mall and they bought it years ago. At the time, it was only worth 1 million. I think the assessed value today was around 4 or 5 million. And now they have adult children, and so they were working with our wealth advisor regarding investments and estate planning. And they thought, well, how can we mitigate some of those capital gains taxes? Because we know that on the last death, there's going to be a huge unrealized gain here that's going to be taxed. And so working with the wealth advisor, we were able to put a whole life insurance plan, which is a permanent insurance plan, to negate those capital gains taxes. Now, I don't want to get in the weeds here, but it's whole life insurance or permanent life insurance is something we use to at least minimize some of the capital gains taxes at death. Charitable giving. So what does this mean? Well, oftentimes we run into members here at Van City that believe in a cause or a charity. And so maybe they're not ready to make a donation today, but when they pass away, they want to leave a legacy behind, and knowing that they're going to contribute to that cause or charity. An example of this would be at the beginning, Kristin had, introduced me as an advocate of the BC Lupus Society, and I have been for over 20 years. And the reason being is it is really near and dear to my heart. My sister passed away from lupus over 20 years ago, and at that time there was no real remedy for living with lupus, and so it's an autoimmune disease. Very hard to get over colds and things like that because you don't have any white blood cells. So as a advocate of the BC Lupus Society, I was able to go to these galas and functions and doctor presentations. And one way we were able to, fund some of the research was through a life insurance plan, naming the charity as the owner and the beneficiary, so that when they passed, they were going to leave a tax-free benefit to the BC Lupus Society. So I thought this was a really good way to, if you believe in something that's true to your heart, then maybe life insurance as a charitable giving is the right solution. Part of our job here at Van City as well is to review current policies that we have in force here at Van City. So oftentimes I'll speak to a member and they have a life insurance plan that perhaps they forgot about, or it was applied for a long time ago and they have no idea what the coverage amount is or who the beneficiaries are. And so my job, it's really important to let the members know, look, this is how much you have. These are the beneficiaries. Are they still current to your situation today? Is your coverage amount still current to your situation today? Because as time goes on, our life insurance changes. Just because maybe we've paid off our mortgage, or maybe we added a new addition to our family. So it's a good idea to review your life insurance plans, I would say every 5 years at the very least. Now, when you have a term life insurance plan, there usually is either an expiry date or a time to renew. And so it's important to keep that date in mind because your premiums are going to go up. And so it's a good idea to review your plan and make sure that you have all your options available to you. Lastly, the last bullet point, make sure your insurance professional is still in the business. There's a lot of advisors out there. Sometimes they stay in the business for a long time and some stay for a short period of time. So it's important to know who your insurance advisor is so that they can review your plan with you and making sure they keep in touch with you and you have the right contact info. Otherwise, what will happen is that insurance policy will be serviced by the carrier itself. So whether that's Canada Life, Manulife, Empire Life, whomever that may be. So in summary, Tina touched on a lot of these points. I just kind of want to bring it home here. Get a will. It's probably one of the first things anyone should be doing when they're looking at financial planning. It sets the foundation up for a really good plan based on your needs. Make sure it's current. If you haven't looked at it for 20 years, make sure you want your assets to go to who you want them to go to. That's pretty important. Name an executor. I've had some experience with this. Usually, and not exclusively, but usually it's the child, the adult child, that is the executor of a parent, for example. I know I am for my dad, so that I can delegate his wishes out when he passes on. Power of attorney, I think this is really important. Some people just overlook it. And the reason being is that I've had some experiences, not only with members here, but on a personal note, that have had a bout with Alzheimer's or dementia, and what a debilitating disease that is. And so sometimes they're unable, well, most of the times they're unable to make those financial decisions. And so the power of attorney is able to do that on behalf of that person. Again, like Tina said, make sure your beneficiaries are clear and concise, whether it's an investment or an insurance policy. It's good to review these types of beneficiaries. Now, Tina is smart. I think I'm okay. We are professionals in investing, and I'm a professional in insurance planning. But I think it takes a team of professionals in order to put a good plan together for your situation. So whether it's an accountant or a lawyer, someone of this magnitude to put those wills in place, or the powers of attorney, and maybe you need an estate planning lawyer to put something together for you. These are all good people to talk to when putting a financial plan together. Financial planners, they can quarterback the whole plan for you. So just keep in mind that it takes more than one professional to put a good estate plan together. And that concludes my section. Over to you, Barry.
Thank you, Ricky, and thank you, Tina, for the wealth of information that we shared this afternoon with our audience. Now, this is the time for the Q&A, and we have a number of questions that have come in. Unfortunately, we're having a little bit of a technical issue. I'm not sure if we're able to publish all of the questions, but I will do my best to read them out and moderate the Q&A session here with our presenters. So the first question that has come up several times here and is about the webinar content and whether the recording will be available. Yes, a recording will be shared with those who registered to the webinar. So you will be receiving that information. And also it will be published on our YouTube channel for Vancity. So all of this information will be available for you to review at a later time. So yeah, rest assured, I appreciate, I know there is a lot of information that was covered here today, so you'll have the opportunity to review that. The first question that I'm going to pass on to Tina. Tina, the question comes up from one of our audience members who's in their 20s, and they don't have dependents, and they're wondering if they should have a will.
Thanks, Barry, and that's a good question. And in my personal opinion, yes, you should consider having a will, because the will is a guiding document to administrate your estate. So even if you may not yet accumulated many assets or property, having a will gives you the power choice and puts you in the driver's seat and how you want your wishes to be clear. So yes, I would consider getting a will.
Thank you, Tina. Next question is for Ricky. Ricky, you mentioned that to ensure that your insurance or protection agent is still in the business, One of our audience members mentioned that their insurance agent is no longer in business and they're not too sure how to go about getting some help and advice with respect to their current insurance policy. Maybe you can help us with that question.
Yeah, good question. So what happens when your advisor decides to call it quits? Maybe he or she will retire, or is just out of the business in general. So whenever that happens, the carrier becomes the servicing advisor. So maybe you have a Manulife plan that you need information on. You got to change a beneficiary or something like that. You would contact the insurance carrier directly. There's usually a customer service line. They would just ask for your policy number, and they would be able to address any questions that you may have. There's one other option as well. You could do an agent of record change, which means that if your advisor has retired and you're looking for someone new that can service the plan, or maybe you're looking for insurance advice, you can do an agent of record change when you've met that person that you get along with and perhaps can help you along the way down the road.
Thank you for that answer, Ricky. I've noticed there are several questions that are quite technical in nature with respect to either the taxation standpoint or the legal standpoint. So I just want to emphasize to our audience members, it's always important to also seek legal advice and taxation advice when you're structuring your will and when you're planning to transition your estate. Of course, the information that Tina and Ricky provided today is general in nature, so each person's situation and circumstances are unique to their own personal needs. But just want to remind our audience members here that this information, again, very general in nature. So please consult with professionals, consult with an investment advisor such as Tina or a wealth protection specialist such as Ricky when it comes to investments and insurance needs, and then also consult with legal and taxation professionals. But with that being said, maybe there is a question that's come up a couple of times here, and I'm going to pose that question to Tina. If you could maybe help us a little bit to understand if there is any major differences from an estate point of view when it comes to a common law partner versus a wife or a husband. And I know that each province is a little different. So maybe I'm just from CRA's point of view, there is one general definition on that, but maybe from your point of view, Tina, as an advisor, if you could shed some light on that.
Yeah, so when we designate beneficiary, there is saying, is this a spouse or common law partner when distributing, when it comes to naming a beneficiary in your registered retirement savings plan, your RIF. So even for your RIF, we look at spouse as well as a successor holder. And there is, I really want to stress on what Barry was saying is because how the tax view common law and spouse is different than what sometimes the state views it. So I really think it's the best question to ask the lawyer. But we do name beneficiaries when is it a friend? Is it a partner? Like, is it a spouse or a common partner? We do ask specifically. I hope that answered your question.
Thank you for that, Tina. Maybe we can keep you on the line here, Tina, for a second. We have another question. You mentioned having a successor named for your registered account. And we have a question here about an RRIF, registered retirement savings account. That's a RIF, sorry. And how does that apply to having a successor designated there?
Perfect. I think during the webinar, I talked about tax-free savings account where you can name a common law partner or a spouse as a successor holder. It also applies to retirement income fund, RIF, registered retirement income fund. So if you have a spouse, you can name them as successor holder. And what that really means, if the holder is deceased, then it carries over to the surviving spouse. So they will continue operating the account, they will continue to receive payment, and it will be rolled over tax-free. Hope that answered the question.
Thank you, Tina. Ricky, the next question is to you. We have a question if someone has a life insurance policy that names a beneficiary that's different than their will. What happens in this case? And I know there are some legal and tax implications on both ends, but from your perspective, when it comes to life insurance policies that don't match the will, what is typically the procedure there?
This is a really good question. I get this a lot, actually, and it's usually during the discovery process because we're trying to figure out who we should name as beneficiaries. And then oftentimes the member will say, well, I have it all laid out in my will. Well, that's all good. But when it comes to life insurance proceeds, which are tax-free, by the way, whomever is named the primary beneficiary on that life insurance plan, the proceeds go directly to them, regardless of what the will states. And so that's why, Tina and I have made it a point to say that you need to review your beneficiaries. Well, whether it's an investment account or an insurance policy, you have to make sure that the beneficiaries are current to your situation today. Because if it's not, and you don't want a certain percentage going to someone, it's going to be too late. And I mean, I suppose you can get a lawyer involved, but I think for the sake of ease, whatever is named in the life insurance fund, whomever is named in the life insurance plan is the designated beneficiary, and they would receive the proceeds tax-free, regardless of what the will states.
Thank you for that answer. The next question maybe I can take briefly here, and some of our audience members are asking about professional financial services organizations that can act as executors. And the question is, are there any organizations that our audience members can seek to name them as their executors in to handle their estates? And the short answer, yes, there are several organizations across the country. One organization we deal with here at Vancity that we refer members to is Concentra Trust Services, and they also offer professional executor services if any of our audience members are curious about that. But if anyone is interested in additional information around will and estate planning, we also offer will and estate planning consultations here at Vancity. You still will need to work with a legal professional to put together your will. But if you're looking for general advice and general information around resources and what information to keep in mind when you're planning to, prepare your will and prepare your estate, we're happy to provide that service to you. And I'll share that later on at the end of the presentation, when we're done with the Q&A. But maybe the next question will go back to Tina again, if that's okay. Tina, I know we cover a lot of different terms and concepts that sometimes are not very familiar to our audience members. We deal with these terms on a regular basis, but maybe one of the questions that's come up here is if you can help us again define what is an estate. We mentioned a couple of times in the presentation that you can name your estate as your beneficiary, and I know this is something that we've said several times throughout the presentation, but maybe you can just help us with the general explanation of what that stands for.
So estate, I'll give you a few examples. Earlier I said that if you name a beneficiary in your account, it bypasses the will, which is it's from the estate. So things that bypass it would be RRSP, TFSA, and RIF, if you name a beneficiary. If you don't name a beneficiary in a registered retirement savings account or a RIF, and you just leave it blank, then it will go into your estate, meaning it's assets that you own, but you don't have anybody to name, and it has to go through the will. there's one thing that's common is property. Your property, so my father is single and he did not add me or my brother's name to the property because we didn't want him to lose the opportunity of not being eligible for the capital gain provision. So in the event something happens to my dad, his value of his home, principal resident, will go into the estate, which is forming part of his assets. And through his will, he's going to say, okay, well, I want Tina to receive half. I want my son to receive half. Does that answer the question, I hope?
Yeah, thank you. That's a really good example, and it's quite helpful. I'm going to switch it over to Ricky, if that's okay. And just mindful of the time here, we'll try to get through a few more questions. Ricky, the next question is around donations. I know you gave a really good example here about a charitable donation. And the question is around if someone is at an age where they could potentially have challenges to qualify for an insurance policy. Any recommendation or any advice around, using insurance as a form of charitable giving?
Yes. So one of the caveats of using life insurance as a charitable giving towards a cause or a charity is that one needs to be healthy, somewhat healthy anyways. We do business with an insurance company that helps the hard to insure. So there's always that option. This Canada Protection Plan, you may have seen the commercials on TV. If not, then if you have an existing life insurance plan and perhaps you've outgrown it but want to still keep it, you can always assign that policy over to the charity, which is great. This way you don't have to go through the medical underwriting. You would just reassign that policy right to the charity and they would be the beneficiary.
Great, thank you, Ricky. Switching over to Tina, there is a lot of questions here, so thank you to our audience members for keeping the questions coming. Tina, the questions are around adding children's name on properties. So the common question that's come up here, can I add my child's name on my property? I know you spoke a little bit about that and some of the tax implications that members and audience members need to keep in mind, but maybe we can ask you to shed some more light on that.
Yeah, I'll definitely elaborate. I'm just going to use an example because my dad wanted to add myself onto his clear title principal resident property. And we seek legal advice. And for our family, we decided that's not best to add my name to the property for the following two reasons. One, he will lose the eligibility to claim it as principal resident because I am now, if I were to be joint owners, meaning I own 50% of the home. And also, I also have to pay immediate deemed capital gains on it because he purchased the home back in the 80s. Now you can imagine how much it's worth. We also didn't want to pay that deemed disposition and triggering that gain. So that's why when you're adding an adult child to the property, those are things that you want to consider. Well, what are the pros and cons by doing that? And if it's simply just to ease estate planning purposes, most often than not, it's best just to go through the will, meaning the estate, let it have the asset into the estate and follow the legal documentation through the will on how to divide the assets up.
Thanks, Tina. Maybe another question to you, and then I'll pass another question to Ricky. The question is around someone passing and let's say in the case of a former spouse, does the beneficiary designation automatically change if they marry, divorce, or separate?
Oh, that's a good one. No, a new marriage no longer automatically revokes the will. And beneficiary designation that's designated through an insurance or registered retirement savings account or tax-free savings account also does not automatically change or revoke the new marriage either. So it's best to update, it's best to connect with the advisor and the insurance company to have those changes, any major event changes.
Thanks, Tina. Last question here, and thank you again to our audience members. Very engaging Q&A session here. Ricky, the question is there a cost to consult with you about insurance needs?
That's a comical question, but a good one. Yes, of course. Everything comes with a cost, and so when we're looking at, putting together an insurance plan for our members, whether that's life insurance, disability, or critical illness, there are premiums that are involved to make sure your protection is in place as you pay the monthly premiums. Now, those premiums are based on a few factors. One is age, the other is gender, and as well as average life expectancy. So the younger you are, the more cost effective the plan will be. The older you are, the higher the premiums get. And so, these insurance companies have actuaries to calculate the different costs of life insurance and disability insurance and critical illness insurance. They're the real experts when it comes to, how they figure out the premiums for a particular coverage. But yes, there is a premium. There are premiums that you need to pay every month or annually to make sure that the coverage is in place.
Thank you for that. And I'll add just an additional point that contacting and speaking with Ricky or Tina is offered free of charge. You're welcome to have a consultation and a discussion. The premiums that Ricky was alluding to are the premiums charged by the insurance providers for the cost of providing the insurance coverage. So with that being said, we are at the end of our webinar. So this brings us to the conclusion, which is the first in the series of financial planning webinars that are held throughout November. The next webinar about investing in your kids' education will take place on November the 9th. And the information about registering for the next webinar and the remaining series of webinars throughout November are also available on vancity.com on our website, and it'll be included in also your email notification. So after this presentation, you will receive, for those who are registered, you will receive a follow-up email with a link to the recording, as well as an invite to book an appointment with our estate and will consultant, again, free of charge, and any additional information that we're able to share with you will be included in the follow-up email. With this being said, I'd like to take this opportunity to thank our host, Kristin, and our guest speakers, Tina and Ricky, for sharing the valuable information about estate planning. Also, a big thank you to our audience members for joining us today. Again, we will be posting the contact information here. You can reach Ricky and Tina directly through the information that's shared on this slide. And if we could ask you for taking a moment to, if you could please, to follow the QR code on your screen and complete the short survey. It would help us tremendously to ensure that we provide the content that's really relevant to what you're looking for, and keep that in mind for our next series of webinars. So with this being said, I would like to thank you all and wish you a great rest of your day. Thank you.